So, hello, hi. It's really nice to see you again, and congratulations for having a lecture during Golden Week. No, it's actually it's good because it gives you the chance to feel special. Sometimes you feel that you're ordinary, that you're living a common life. So see the others, they're having vacations now. They're traveling and you're having a lecture. You're special, okay? It's a good thing. I'm also special. So I've got a cold. My voice is not so clear today. Actually today, nothing is functioning for me. I made a mistake with the key. I had to go back to the office and bring the right key. Then, when I was re-entering the classroom, I saw a student writing his name, taking a copy, and trying to leave from the door I was entering. So he saw me, I saw him, and he went to another door, and I saw him leaving. It's okay. Well, actually, the bad thing is that I know who he is because he was my student in another lecture, but it's okay anyway. I like him and he likes me. We send each other messages through Line, we are friends, so anyway. So it seems that today is not a good day for a lot of people because I have a friend. He lives in Osaka and he likes, he lives in Kyoto and he likes a girl who lives in Osaka. So once a week he travels to Osaka due to his job and he meets her. He asks her to go for dinner or coffee. So once he told her, something ko, so her name is Maruko, yes, okay. So he told her, ABC ko, wouldn't you like to come to Kyoto once? I would like to show you around. So I asked him, and what was her answer? She told me, she told me that, Kyoto is so far. And I was thinking, yes, she's right. Osaka is like a foreign country. It takes you 1 hour to go there. I always go to Osaka with my passport, because it's very far. So, but he's my friend, so I told him, no, she's not, she's saying silly things, so Kyoto and Osaka, it's only 1 hour, it's nothing. So, today, he sent me a message. And he was really angry, and I asked him, why are you angry? He told me, I was having a look at her Twitter account, and she was posting photos of Saga Arashiyama in Kyoto, and she was saying, Golden Week with my friends in Kyoto, I love Kyoto. So I told him, that's so sad. And I told him, so what are you going to do? And he told me, I just unfriended her. She's not a friend of mine on Twitter anymore. So that's his revenge. I'm not sure if that's okay. Yes, so bad things happen. But yes, anyway, we need to start with the lecture. So last week we were talking about the places where we can find Japanese law, the sources of law, which means the rules the judges use when they make decisions. We talked about the difference between mandatory provisions and discretionary provisions. We said that precedents, there is no provision which says that precedents are binding, but they are binding in fact. In Japanese, it is called 事実上の拘束力, that they are binding in fact. So, and we also mentioned the reasons why. So, yes, let me just show you something from today's material. Here. So last week, I told you that Supreme Court decisions have a binding force in fact. I also told you that Supreme Court decisions do not change so easily, because otherwise there would be no legal certainty, hotiki ante se. You would not be certain what is allowed, what is not allowed, what is legal, what is illegal, etc. So, Supreme Court, Saiko Saibansho, once it makes a decision, it does not change it unless the social circumstances have changed. And let me give you some more detail regarding this case. We were talking about the share in inheritance, sozoku bun, of children out of wedlock, which means children who were born without their parents being married. Article 900, Item 4 of the Japanese Civil Code used to say that children out of wedlock receive half of the children in wedlock. That was the previous provision. And as you can see, this is some new information. The Supreme Court has said 1, 2, 3, 4, 5 times that this provision is constitutional. What happened? People were feeling that this is so wrong, especially lawyers. So they were bringing lawsuits again and again. Usually, the Supreme Court, once it makes a decision, it does not make a decision on the same subject again. It does not accept your lawsuit, the Supreme Court. So you can see that the Supreme Court waited for 5 years, then for 3 years, 1 year, 5 years, and made 5 decisions saying this is okay, this is constitutional. However, in 2010 and 11, what happened? We had 3 High Court decisions saying that this is unconstitutional. High Court decisions have no meaning. Why? Because they are not Supreme Court decisions, which means that if I am a High Court judge in Tokyo, I do not care about the other High Court decisions. I judge the way I want to. But here you can see that we have the Tokyo High Court, the Nagoya High Court, and the Osaka High Court saying within 2 years, for 3 times, that this provision is unconstitutional. So, the Supreme Court then said in 2013 that yes, this provision is unconstitutional. So here you can see how it works. When you have a Supreme Court decision, it is binding, but it can change. In order to change it, you need to show to the judges that now we have a different society or different circumstances, etc. Now, trials. So here we start with today's content. What's a trial? Saiban, social. It's a procedure to have a judgment made by a public third party when we have a legal dispute. So this public third party in Japanese is daisansha. So this public koteki daisansha, public third party, resolves a legal dispute. And we have 3 categories: criminal trials, civil trials, and administrative trials. Criminal trials please underline crime, and please also underline punishment. So, in cases of criminal trials, we have an act which is or is not a crime, so please underline crime. And we decide what punishment to sentence regarding that crime. In case of a civil trial, we have individuals and the judge resolves a dispute between them. And in administrative trials, we have administration, that means the state, versus individuals. So, please be careful. In numbers 1 and 3, it's state against us. In case 1, it's the state against the person who is said to have committed the crime. In case number 3, it's us asking the state to change an action. For example, number 3, you graduate in the future from Kyoto University and you open a cafeteria. You call it Kyoto Cafe. And each time a customer comes in, you say, Okini, so Kyoto-like. Yeah, it was funny. A French friend of mine came to Kyoto 2 weeks ago, and he was trying to say Okini, but he was saying bikini. So the people around him were treating him like a pervert because he was going to stores and there were beautiful ladies, you know, the owners of the cafe, and he was like bikini. So don't make a mistake. Okay, it's Okini, it's not bikini anyway. So yes, and you open a cafe, and for some reason the state tells you, no, we are going to close your cafe. It's an administrative trial. You will ask the judge to allow you to reopen your cafe, which means that the judge will say that the action of the state to close your cafe was illegal, for example. So it's you against the state. Now, let's go back to last week's material. Number 3. If you don't have it with you, you can find some copies there. Yeah, so please have a look at this slide, which remained quite unexplained last week. Now, I told you that we also have, so administrative trials are easy to understand. It's you against the state, you against the municipality, you against something which has to do with the state. I told you that we also have civil trials and criminal trials. So, what's the relation between civil and criminal trials? Actually, you can have the same incident, the same case, going to both civil and criminal trials, to answer also Matthew's question 2 weeks ago. So, let's say that Y was driving his car carelessly and he hit X and caused him serious injuries. This case can go both to a civil trial and a criminal trial. What's the difference? As I told you, civil trial is individual against individual. In this case, X against Y. So, X will ask Y to pay him, so here, to pay him for his damages, for his hospital fees, for the money he could not earn he could not go to his part-time job because he was in hospital, etc. So the civil case will be individual against individual, X against Y. Usually you ask for money, usually. What's the criminal trial? The state against Y. Y did a very dangerous thing. He should be punished. It's not X against Y. It's the state against Y. The state will take him to court and ask the judge to sentence him with a punishment. For example, to go into jail, etc. So, to summarize, the civil trial is individual against individual. Usually you ask for money or you ask for a thing or something. Criminal trial, state against the individual. The state asks for the punishment. And administrative trial is usually you against the state. You ask the state, the judge, to make the state undo something, etc. Now please be careful. In this case, if we had only a criminal trial, X would receive no money. Maybe Y would go into jail, maybe Y would be asked to pay some fines to the state, but X receives nothing. So X also needs to go to a civil court and ask for compensation. Two different trials for the same case. So that's all also for last week's slides, and let's go back to today's material. So, courts are doing a very important job. And students usually ask me, so, why? Give me a reason why I would want to become a judge in the future. I usually give them one reason, depending on their personality. If they have a strong desire for justice, I tell them, if you become a judge, you can implement, you can realize justice, you can create justice. If they don't care about justice, I talk to them about salaries. I tell them, do you know how much a judge makes? They tell me no. So, the students who were attending my lecture last year, maybe they remember. I have a friend who was a judge at the Tokyo High Court, and once he drank too much sake. So he asked me, so Antonios, would you like to know how much I'm earning? I was, yes, please tell me. So he was like, I'm 57 years old and I'm making 24 million per year. 24 million yen, okay? So that's a very good reason to become a judge anyway. It depends on you. And so now he is a professor. He retired from judge. And he told me that, you know, Antonios, I was shocked. You professors, you receive less than half of the judges. I was like, yes, I know that. So welcome to this world anyway. So if you want to make money, don't become a university professor, okay? Okay. No, I'm serious. I mean that. So if you like money, if you want to make a lot of money, there is the exception of the professors of the Faculty of Medicine, okay? They can make a lot of money because they can also work in the hospital, but not us anyway. So, now, yes, so as we saw, judges are making a lot of money. Why? Because otherwise, like as it happens in foreign countries, some foreign countries, the parties, Tojisha, would try to give them an amount of money in order to change their decision. So, yes, I was joking about the salary, but it's important for a country to make sure that judges are earning as much as they should. Otherwise, they would be tempted to such offers. Now, just to give you some additional information about salaries. Today I'm ill, so anything, I can tell you anything. It's as if I'm drunk, Next week I will tell you, did I say that? No, I did not. No, I don't remember. So, I have a friend who's a lawyer in Tokyo, and he was having a case of a famous gravure idol. So a model. And he told me about her salary many years ago. She was famous. You would see her on TV a lot. So according to him, her contract was that she would receive 50 million yen as a minimum salary, which means if she appears a lot on TV, she could make more money, but the minimum salary would be 50 million. So, rethink your careers, When you graduate Kyoto University, rethink your careers. It's difficult for you to become gravure idols now, but but it's important also to think whether you want to have a lot of money or something else. In the Faculty of Law of Kyoto University, there are many professors who have passed the bar exams. They could become lawyers. They could make a lot of money, but they became professors. There is a reason for that. It's not always the money issue. So, anyway. Now, the function of trials is very important, but there are some cases where the judgments can worsen or make more complicated human relations. As you remember, this lecture is called Law and Culture in Japan, so we also need to talk about Japanese culture. This is a very interesting example, very famous case. It's a decision of the Tsu District Court, Shihou Saibansho, in 1983. I was born in 1980. X1 and X2, they were neighbors of Y1 and Y2. They both had children. So one day, X1 and X2 told Y1 and Y2, could you take care of A? So their children, they were playing a lot, often together. And that day, X1 and X2 wanted to go for shopping. So they told A, come here, we're going for shopping. A said, no, I'm not going with you, 3 years and 4 months. So they said, okay, so can we leave him to you? And Y1 and Y2, they were quite busy because it was a holiday. So they were cleaning, etc., the house. But they told X1 and X2, they will be playing together, so I think they will be fine. But 1 hour later, A and B, they went outside, and A drowned in a pond, which was nearby the house. Now, you need to see this case from both sides. If you are X1 and X2, your feeling is, hey, we asked you to take care of our son, but you didn't. You let him go out, he's only 3 years old, and you let him get drowned. If you see the case from Y1 and Y2's viewpoint, we were so busy and you knew that. You should just take your child with you, and you left him to us. We were doing our best. So you can understand both sides. Now, what happened is that X1 and X2, they sued Y1 and Y2. not only Y1 and Y2, they also sued the state and also the prefecture, etc., because they are managing the pond. Okay, they are responsible for the pond. What happened is that the court admitted only the responsibility of Y1 and Y2. So, X1 and X2, they were trying to make the state and the prefecture and the municipality understand that they also bear responsibility for the pond. But they failed to do so, and unfortunately, the court admitted only the responsibility of Y1 and Y2. Why am I saying unfortunately? Because it was almost 40 years ago, 35 years ago. So you can understand how people in the neighborhood reacted. They were like, "You are so bad guys, X1 and X2. They were so kind, they were taking care of your child, and now you're asking money?" So, as you can see here, also the mass media strongly criticized this decision. On television and in the newspapers, they were saying that this destroys the neighborhoods. Nobody will leave his child to his neighbors anymore. I'm not sure if what the media was saying is right or wrong, but anyway, there was strong public criticism, and it was 35 years ago. So what happened? People in the neighborhood, they started calling X1 and X2 and saying many bad things to them. So X1 and X2, they withdrew the lawsuit. They said, okay, although they had won, they withdrew the lawsuit to escape from this bad situation. You would think that things would end here, but it's Japan 35 years ago. So what happened is now that people started criticizing Y1 and Y2. Why is that? Because they were making koso, an appeal against this decision, which is their right. They can do that legally. So people would now call Y1 and Y2 or send them letters and tell them, "You are so bad, you killed this child and you're still trying to escape your responsibility." So Y1 and Y2, they withdrew their appeal, so there was no case, although we had a decision. So if you see that from the viewpoint of X1 and X2, they lost their child, they paid a lot of money to lawyers and to the court, a lot of time dedicated to the court procedure, they won partially, and then they were criticized and withdrew the lawsuit. On the other hand, Y1 and Y2, they were also, of course, shocked by the death of the child. They were shocked by the fact that that a lawsuit was filed against them. They lost. They made an appeal, a lot of money and time. Finally, they were criticized. So, what happened is that both families lost a lot of money and time, and actually nothing happened. After this procedure, the Japanese Ministry of Justice made an announcement saying that, going to the court is your right. You can do that. It's your legal right. Because, as you can understand, although it was a legal right, it was not treated like that. So this is a very famous decision because the legal part is of course interesting. It admitted that the parents bear responsibility. It's called a duty of care or a duty of diligence, juigimu. But not only that, it revealed how the Japanese society thinks about lawsuits, how it thinks about people trying to enforce their rights. Okay, so this decision has been analyzed not only from law professors, but also from professors of social studies, etc. On the other hand, there are also some cases which have changed society in a better way. The first example is that of the so-called 4 major pollution lawsuits. They were filed during the second half of the 1970s. So you can understand it's the period after World War II, when the Japanese industry was growing rapidly, which means that we had a lot of factories working, which means pollution, which means also diseases, so people were getting ill. Now, this is a photo, an actual photo from the Minamata social. You know, Minamata disease, you can Google that later. So this girl is actually a victim of the Minamata disease. All 4 cases were won by the lawyers. So the Japanese government changed its policy regarding pollution, etc. Why was that necessary? Because the Japanese government then was in favor of the large companies, as it is happening now in some Eastern Asian countries or African countries or also in European countries. When you're having your economy growing, you sometimes try as a government to ignore some things. So the Japanese government was a bit trying to ignore pollution because it was good for the Japanese economy that the companies were doing a lot of job. So the 4 lawsuits, they changed this. And after the lawsuits, we were having a stricter system regarding pollution. Another example is the also famous anti-smoking right lawsuit, also during the second half of the 1970s. So, what was happening then? If you go now into a Shinkansen, in most areas you cannot smoke. There are only some limited spaces where you can smoke. That was the other way around in the 1970s. You were free to smoke anywhere. So, many people did not like that. They were feeling that their health is damaged by the smoke of others. During the 1970s, it was scientifically proved that smoking is bad for human health. So, some lawyers and university professors, they created a team and they filed a lawsuit asking the state and also the national train company then to create more spaces where smoking is prohibited. They lost. They lost because the judge said that, you know, you don't live in the trains. You take the train maybe for 1 hour, 2 hours, but eventually you get off. Which means that, yes, maybe this is not so pleasant, but it's only for a limited period of time. It's not forever. Second, it's within the limits of what you should tolerate. It's not something too much. And some other reasons. So they lost the case. But the train company changed its attitude and created more wagons where smoking was prohibited, although the train company won the case. So you can see that it's not always about winning. Of course, sometimes you have to win in order to make things change. But there are also some cases where you can lose, but still change the society. As you can imagine, sometimes these lawyers, they are criticized. People say that you are mixing up politics and law. Okay, so this should not be done through the courts. This should be done through the gikai, the diet. But I think it's okay. And it's also a good reason for you to become lawyers or to become mass media employees with a good way of thinking. Okay? So mass media employees who would not criticize X1 and X2 for filing a lawsuit, etc. So both are important. Any questions up to this point? Anything you would like me to explain additionally? No? Come on, it's Golden Week. Are you sure? No questions? Okay, so let's continue. We will have a break in 10 minutes. No, sorry, in 5 minutes. So, who would like to read Article 76, Paragraph 1 of the Japanese Constitution? Okay, thank you. Okay, so you are yours again?
Yes.
No way. Okay, thank you. Yes.
The whole sentence, 3 of them.
Let me check that. 70. Yes, yes, please.
The first one, the whole judicial power is vested in Supreme Court and in such inferior courts as are established by law. The second one, no extraordinary tribunal shall be established, nor shall any organ or agency of the executive be given final judicial power. And third one, all judges shall be independent in the exercise of their conscience and shall be bound only by this constitution and the laws.
Thank you. So, before talking about paragraph 1, you know paragraph 3. We have already discussed about this. Paragraph 2 is also interesting. It says that no extraordinary tribunal shall be established. So students are like, okay, so, well, extraordinary courts, tribunals, are usually dangerous. Why is that? Because they are established extraordinarily to deal with a certain case, which means that if you are, for example, the Prime Minister, you would establish an extraordinary court to deal with a certain case because you are afraid that the state will lose the case if the case goes to the ordinary courts. So you appoint judges who are your friends. So that's why extraordinary courts are prohibited, because they're dangerous. And now, number 1, paragraph 1, it says, the judicial power belongs to the Supreme Court and to the inferior courts. So please be careful. In Japanese, the Supreme Court is Saiko Saibansho. The inferior courts are Kakyu Saibansho for the Japanese students or for the international students who want to learn more Japanese. Okay, more difficult Japanese. Not only I have a pen, I have an apple. Okay. Now, the question is, yes, the Constitution does not explain which the inferior courts are. Why is that? Because it's not important and it can change in the future. So, in the Constitution, there is no provision saying which the inferior courts are. Why is that? The Constitution is a symbol. It's the superior law of the country. It should not change so often like it happens in my country, in Greece, for example. Okay, so in Japan, it works. It still works as a symbol. So you do not provide details. No. So if you want to know which the inferior courts are, you need to go to another piece of legislation, which I'm not going to introduce you today because it's too much. So if you have a look into its provisions, it says the inferior courts are the high courts, the district courts, the family courts, and the summary courts. So the Japanese court system is like this. You have one Supreme Court in Tokyo. You have 8 high courts in the major cities, for example, Tokyo, Nagoya, Osaka, not in Kyoto. So Kyoto is not a major city. No, it is a major city. We have Kyoto University here. Okay, so anyway, but we have 50 family courts and 50 district courts, one in each prefecture, and sometimes 2 in big prefectures. And we also have summary courts for cases of small amounts, etc. So, the Supreme Court is important. Why? Because it's the Supreme Court. Yes, but why? Oh, because it's mentioned in the Constitution. Yeah. So, it's a body which is so important that it is clearly mentioned in the Japanese Constitution. One Supreme Court in Tokyo, 15 judges. Please be careful. They are not all former judges. Some of them are diplomats. Some of them are professors. Some of them are former administrative officials, etc. Some months ago, yes, a former Tokyo University professor who was retired and then working at Waseda University, he became a Supreme Court judge. So you can see that university professors can also become Supreme Court judges. So let's have a 5 minutes break. If you have any questions, feel free to ask me.
It was just open. Maybe like then why don't Like here they might be like not belly. Yeah, like here I can tell where over there I don't know. Does it feel like being off?
So let's continue with the second part of this lecture. It feels like a movie theater, doesn't it? You have a short break, you can eat popcorns, you can drink juice, and you have the second half. I was talking with some friends of mine who are Kyoto University graduates. They graduated 30 years ago. They were asking me, do the students come to the lectures? I was like, yes, they do. See, it's Golden Week and we have many students. They were like, no, 30 years ago, we were not going to the lectures. All the important things, we learned them by drinking alcohol with our friends. So I was like, no, you don't learn important things when you drink alcohol with your friends. Maybe you learn how to damage your health, or you learn how to commit a crime when you're drunk. But they were saying that, nobody was going to the lectures in the past. But things have changed. In Greece, it was really interesting because the professors, they were not coming to the lectures. That's a unique case. I remember our contract law lecture, a very famous professor. He became Minister of Justice later. So we were also waiting for him to come to the lecture. He came to the first lecture. He said some general things. Then from the second lecture, it was his assistant. She gave us 13 lectures, really interesting. She was really good, but she was not so famous. And when we were having the last lecture, the final lecture, the 15th lecture, he came again. And he said the same things he was saying us during the first lecture. So it was really funny because we only saw him twice. But the most interesting part was a friend of mine. He was also only going to the first and the last lecture. He was shocked. He was telling me, it's like a deja vu. I have seen this lecture. I have seen him again. So I was like, yes, because he came to the first and the 15th lecture, and you missed all the other lectures. So it's actually a deja vu. You have seen him. You have listened to what he's telling you. So I think you should attend the lectures because I'm really regretting. I was a good student. I was in the top 10 of Athens University Faculty of Law during during the first, second, and third year. Don't ask me what happened during the fourth year. I was too confident, so there were some lectures which I was not attending, and I really regretted that. You know, if you try to understand the same things by reading a book, it's different. But you can only understand it afterwards, okay, not beforehand, so that's the bad thing. Anyway, so, in Japan, we have the so-called three-tiered court system, Sanshin-sei. So usually students who like baseball, they feel really happy. They come to me and they tell me, yes, we have this system in baseball too. If he throws 3 strikes, you're out. So I'm like, well, it's similar but not the same anyway. So you have 3 chances for each case. Now, this also has to do with the independence of the judges. As I told you, all judges are independent, which means that even if you are a new judge of the district court, very young, you're still independent. You can judge the way you want. But your judgment is subject to appeals. Please underline appeal, Joso. So, if your judgment is not good enough, maybe there will be an appeal, and maybe your judgment will be changed by the High Court or the Supreme Court. So students ask me, so what? Do I care? I'm a judge, I'm independent. I will write the decision the way I want, and I don't care what happens with the decision later. And why is that? Because if you want to become a judge later of the High Court, or maybe in the future of the Supreme Court, or maybe a president of a district court or of a high court, they take into consideration what percentage of your decisions has been changed or overturned by higher courts. So, the lower the percentage, the better for the judge. They have an incentive to write good decisions, good judgments, so that they can evolve in the judicial system. Who would like to read Article 32 of the Japanese Constitution? Thank you. Could you pass the microphone to her? Okay. So, I remember that one of you is Chisaki and one of you is Lily. Is that correct? Okay. Now, you are Lily.
No.
You're Chisaki.
Yes.
I knew that. Okay, thank you. So Chisaki, please, could you read Article 32 of the Constitution?
No person shall be denied the right of access to the courts.
Thank you. So, we all have the right of access to a court. Why is this so important? Because sometimes there are also other procedures. For example, you remember the case of the cafe. Oh, yeah, so my friend who, you remember the guy who liked the girl who went to the cafe today? Maybe she's still there. So she went to a cafe in Saga Arashiyama. Do you know the area? It's very close to the station, and it used to be a public bath center. And now the interior has been reformed, and it's a cafe in a center. You can still see the mirrors, etc. It's really nice. I've been there twice, so maybe you could also go there. And if you go during the Golden Week, it's really crowded, so you should avoid Golden Week, okay, after the Golden Week. So, yes, let's say that your cafe was closed by the government, and let's say the government gives you the right to submit a complaint to your municipal office, to Shiakusho. Let's say you do that, and the municipal office says, we reconsidered your case, but sorry, your cafe cannot be reopened. You still have the right to go to courts. So nobody can tell you that, no, this is the final procedure. You cannot go to the courts. That's the meaning of this procedure. So maybe you can use other procedures, but anyway, you finally have the right to go to the courts. Okay, anyway. Now, who would like to read Article 82 of the Constitution? Yes, so Lily.
Am I reading both? Or just...
Both means what? Sorry, I'm not having to read. Yeah, maybe both, yes.
Trials shall be conducted and judgment declared publicly. Where a court unanimously determines publicity to be dangerous to public order or morals, a trial may be conducted privately, but trials of political offenses, offenses involving the press, or cases wherein the rights of people, as guaranteed in Chapter 3 of this Constitution, are in question shall always be conducted publicly.
Thank you. So, trials are conducted publicly, which means that if it's a weekday and you have nothing to do, you're at home, you're watching TV, but there's nothing interesting, let's go to the court. You can go to the court. You can go there and watch other people's cases. It's really interesting. I was doing that in my seminar at Kansai University. I was taking my students to the court. We went to the Osaka District Court to a criminal case. Really interesting. There was the public prosecutor, because it's a criminal case, the state, and there was also the accused, the guy who was accused of the crime. He was 73 years old. He was accused of punching a guy who was 80 years old. And they were both in the court. Really interesting. Because the judge was questioning the victim. And the victim was like, yes, he tried to punch me once, but I avoided that. And then he punched me from the other side, and I did not manage to avoid that. It's like a boxing game, okay? 2 punches, not one. And he avoided the first punch. You know, so interesting. So, yeah, if you go to the court. Or there was also a drug case, a case with a drug user. So I also had some female students. And when we left the courtroom, they were like, oh, he was so handsome. I was like, well, what? So it's interesting, you know, in general, if you go to the court, you will find something interesting. But, yes, let's go back to the article. So, Article 82. Why are trials public? Is it for you so that you can have a more interesting life? No. It's in order to ensure their fairness. What does that mean? Imagine a trial which is not public. If you are the judge, you can sleep like students do during the lectures. Oh, I'm so tired, and this prosecutor, he's so boring. So let me have a sleep. When he finishes, I will wake up and listen to the lawyer. You wake up, the lawyer starts talking, oh, you're boring too, so I'm gonna sleep again. But if you have people watching, you cannot do that. Because people will know that you're sleeping, so they can report you to the court, etc. So that's why the cases are conducted publicly. It was really funny because the judge, he was quite young, and it was a day where he was going to read a decision for another case. Usually, it takes only 5 minutes. When he entered the courtroom, he saw that there were so many students, so he felt a bit happy. It took him 15 minutes. He was explaining everything, even the articles, the provisions, the reasons. So I was listening to the lawyer saying, why is it taking him so long to make the decision today? But even judges, they're human beings. They're happy when they have an audience. Okay, usually nobody goes to the courts. So yes, that was really interesting too. However, you can easily understand that, for example, in cases of sex crimes, the victim would not want people to enter the courtroom, have a look at her or him, and know details of the case. So, according to the article that Lily just read, Article 82, there are some exceptional cases where the trial may be conducted privately. So last week we were talking about what is modern and what is not modern, and I was telling you that these things change. Something is modern, then it's not modern. I remember this example. She was considered to be really beautiful in the Edo period. She was considered to be really beautiful. And he was considered to be really handsome during the Edo period. So, I was thinking about today, I was thinking, okay, so she was beautiful in the Edo period, so according to my opinion, maybe she... Do you know the name? What's the name? Oh yes, Maki Horikita, yes. So, maybe we could say that she is beautiful, but I think she got married and she retired, so she's not modern, but anyway. My question to the students is, okay, if she is he, then who would be him? Any suggestions? No? Okay, so according to my opinion, if she is she, then he would be him. No? No, okay. I will reconsider that. Okay, you have the right to appeal. Okay. Now, we were saying that in Japan, the trials are public in order to make them fair. We have some exceptions where the trial is not public. This is really interesting. It has to do again with the Japanese culture, because this lecture has to do with law and culture in Japan. Saibain, the lay judges in Japan. As you know, this system was introduced in 2004, took effect in 2009. Why did they introduce this system? Two main reasons. To make people understand how the criminal trial system works, and to make them have confidence in the criminal trial system. Let me give you an example. Many people who have not studied law, they ask me this question: how many people do you have to kill in Japan in order to be sentenced with a death penalty? The answer is, if you kill one, most probably you will not be sentenced with a death penalty. If you kill two people, you have 50% chances to be sentenced with a death penalty. If you kill three people, most probably you will be sentenced with a death penalty. Of course, there are exceptions. If you kill one person, but you do it in a very bad way, in a way which is shocking, for example, or shows that your character cannot be repaired, etc., then you can also be sentenced with a death penalty. So, when I explain this, people will ask me, is that fair? Oh, that's a very hard question. You kill one person whose life is supposed to have the same importance with your life, but you're not sentenced to death penalty. So, are your lives truly the same? Do they truly have the same importance? It's very hard to explain. So, this is the image that ordinary people were having regarding criminal trials. They were thinking, something's happening there, but we cannot understand what is happening. So that's why they introduced this system. Now, as you can easily understand, in Japan, people usually are reluctant to become lay judges. There were polls, Yoronchosa, taken when the system was introduced. People were saying no, we would not want to become lay judges. This system has been working for almost 8 years. The data shows that many people resign, they refuse to become lay judges, even though they have been chosen. So, this is the first issue with this system in Japan. As you can see here, people of 70 years or more can decline. So, according to the official data of the state, many people are declining. They say, no thank you, we don't want to participate as lay judges. These trials are in most cases conducted by 6 lay judges plus 3 professionals. So usually you would have in the past only 3 professional judges. Now you have 3 professional judges plus 6 lay judges. And if you go to the court, they will be sitting like this. The professional judges in the middle, 3 on the right and 3 on the left. As you know, and as you maybe have forgotten, I'm Greek, I'm not Japanese. So I speak Greek. And I was asked to work as an interpreter in criminal trials under the lay judges system. It was 2 cases of drugs. A person of Greek nationality caught in Narita airport because he had drugs in his suitcase. And if a person is caught at Narita airport, he is usually taken to Chiba district court. So they were having 2 cases, and I went there to work as an interpreter during the court procedure. So it was really like this. So it's really, you need to be careful with the things you carry when you travel abroad, especially when you come back. Both of them, they were saying that they didn't know about the drugs inside their suitcase. The suitcase had a double, wall. So the actual wall and the plastic fake wall. And in between, they had the drugs. One of them had 3 kilos. So he was sentenced to 8 years in prison with work. And unfortunately, I was informed some years later that he died in prison anyway. So you need to be careful, because in most cases, people, when they are caught at Narita airport with drugs, they say, we didn't know about that. But in most cases, they are found to be guilty. So you need to be careful. Do not accept anything from others. Do not carry what is not yours, etc. You need to be careful. Now, 2 issues regarding the lay judge system. First issue, in the past, you could predict the punishment. Why is that? Because both the judge and the lawyers are professionals. So the lawyer would see, okay, so how many kilos is that? 2 kilos of drugs? Well, usually judges sentence you with, let's say, 6 years. And judges would actually do that. Now, this has changed. You have lay judges. Sometimes you cannot predict how severe they will be. And according to some research, lay judges are stricter, yorikirishi, stricter in cases of sex crimes compared to judges, professional judges. Maybe this is good, maybe this is not good, we don't know. But you can see that something has changed in the criminal system of Japan. So, students who are 20 years old or more, this means students who are registered as voters, they can also be selected as lay judges. Some students ask me, what do we have to do if we are asked to serve as lay judges? 2 things. The first thing is determine the facts. What's that? Let's say you have a case of a person who stabbed another person and the other person died. Yeah. So, what do we have to decide? You have to decide, is it homicide or maybe injury causing death? Who would like to read these 2 provisions? Thank you. So, no, wait. Lady. No. Why do I? Okay, so we have to do something. You have to change your haircut. Okay, the color of your hair? Contact lenses? Something? No, I'm joking. Okay, so, sorry. Okay, yes. So, Chisaki, could you please read the article? Next week, I will remember you, so please raise your hand. Let's make a test. Okay? If I don't remember you, you get nothing anyway, but okay, I'm sure that I will remember you, okay? Okay, thank you. So, yes.
Okay. A person who kills another shall be punished by the death penalty or imprisonment with work for life or for a definite term of not less than 5 years.
Would you also read Article 205 too?
A person who causes another to suffer injury resulting in death shall be punished by imprisonment with work for a definite term of not less than 3 years.
Thank you. So, congratulations, Chisaki. You have reached the maximum for 2 consecutive weeks. So, up to date, you are the top student regarding the 5 points who will be given to you at the end, okay? This might change if the other students start raising their hands or give you some food which has gone rotten and you can miss some lectures, etc. But anyway, you are the top student for the time being. So, when this case goes to the court, you as lay judges have to decide, is it homicide or is it injury causing death? What's the difference? First difference, homicide means I wanted to kill him and I did so. Injury causing death means I wanted to injure him, but he died. So, in the case of homicide, you had the intention to kill him. In the case of injury causing death, you only had the intention to injure him. Please have a look at the Japanese words. Satsujin, yes, you wanted to kill him. The other one is shogai chi shi, which means shogai, injury. That's what you wanted. But the result, chi, was shi, the death. And what's the difference? There is a big difference because in the case of injury causing death, there is no death penalty, and the years of the imprisonment are different. So, as lay judges, you will decide which of these it is. How? You can ask the accused, did you want to kill him? Answer, no, no, I wanted to injure him. Are you sure? 100% sure. My lawyer also advised me to tell you so. I pay him a lot of money, he's a good lawyer. So, how are you going to decide? By using the evidence. Where did he stab him? How many times? How long was the knife? Etc. So, if you read court decisions, you will see a very detailed description of what happened. The knife was 20 centimeters long, he stabbed him 10 times, and you will be like, oh, the judge, he's S, not an M, okay? S and M, he's an S. He is interested in criminal cases and killings. He is describing it so detailed. No, he is trying to give you some criteria, some material to judge objectively which of these it is. Second, after you decide about number one, you decide about this, assessment of culpability, yoke in Japanese. So, for example, if it is homicide, you will decide, is it death penalty or imprisonment? And if it is imprisonment, how many years? So these are the two basic jobs you will do as a lay judge. Finally, 2 slides, we will finish in 3 minutes. Legal professions in Japan, we have the term Hoso legal professions, which describes judges, public prosecutors, and attorneys, and we also have other professions. Abroad, you usually have only lawyers and public notaries. So, you need to be careful. If you ask them, how many lawyers do you have in your country? The number is really large. So you're like, no, in Japan we have only a few lawyers. Yes, but abroad, lawyers are also doing the work of judicial scriveners and administrative scriveners. But they don't have separate professions for that. So you need to be careful when you compare. Question. If you know the answer, please raise your hand. Why do judges in Japan wear a black dress? Why is it black? The color is important. Why is it not green, which is good for your eyes? Okay, you will go to, and next week I will ask you the same question, and you will get double marks if you raise your hand. In Japan, they have badges. I am so envious. In Greece, we have no badges. Nobody knows that you're a lawyer. But in Japan, everyone knows that you're a lawyer because you can put this badge on. So, when you go to a club with a lot of women, they usually put this badge and the women are, oh, he's a lawyer, let's go talk to him, which I could not do in Greece. Anyway, so, yes, it's half a joke, but many lawyers do that. They don't put the badge when they go to the court, but they put it when they go to clubs. Anyway, so, this is the badge of the judges and the court employees. it's a mirror because mirrors reflect the truth. Saying Sai from Saiban. This is the badge of the public prosecutors. It is a chrysanthemum with the sun in the middle, but it looks like frost and sun, which means frost is very cold and sun is really hot, so severe, strict, austere. That's how prosecutors should be. And this, as you all know, is a sunflower, which shows justice and liberty, and a pair of scales, which shows fairness and equality for judges. Usually, this badge, it's not golden, only the outside is golden. So, if you are a lawyer for many years, the gold fades away, the color is not so bright anymore, so people know that you have been a lawyer for many years. So I have many friends who are young lawyers. They put their badge in their pocket to make it lose its brightness so that they can show that I've been a lawyer for a long time. If you pay a lot of money when you register, you can buy a badge which is all golden. It's really expensive, but if you lose it, it's the end. So people usually do not do that. And we will talk about this next week. Thank you very much for attending lecture number 42. Looking forward to seeing you after the Golden Week next week. If you have any questions, feel free to ask me.